Hey, CA Inter students, and welcome. We're tackling Chapter 22 today, the one on companies incorporated outside India. It can feel a little complicated, right? Well, don't you worry. In this quick explainer, we're going to untangle all of it. We'll make sure you're ready for any curveball ICAI decides to throw your way. Let's get right into it. All right, let me hit you with a question right off the bat. Picture this. A company set up in the UK. But 60% of its shares are held by Indian citizens and other Indian companies. So, for your exam, do you treat this as just a regular foreign company, or is it something else? This, my friends, is a classic ICAI trap, and by the end of this session, you'll know exactly how to nail this question. Okay, let's paint a picture with a typical exam scenario. We've got Global Tech Inc. They're a US company and they sell their software to customers in India, but only through their website. They have absolutely no physical presence, no office, no staff, no agents here, just a website. So the million-dollar question is, does the Indian Companies Act of 2013 even touch a company like this? That's the core puzzle we're going to solve together today. Okay, first things first, the identity crisis. Does our company, Global Tech Inc., even fit the legal definition of a foreign company under Indian law? I'm telling you, this one definition is the key that unlocks this entire chapter. Let's break down the official definition from Section 2, subsection 42. There are two conditions, and this is crucial. Both have to be met. Condition 1, it's incorporated outside India. Easy enough. But Condition 2 is the real deal. It has to have a place of business in India, and it has to conduct business activity here. Now, the phrase that changes everything for modern businesses is right there. Place of business can be physical or through electronic mode. That is the absolute game changer for a company like Global Tech. So what in the world is electronic mode? Well, the law defines it very, very broadly. We're talking about almost any online activity you can think of. B2B sales, B2C sales, web marketing, even just using email for business communication. The biggest takeaway for you here is this. You do not need a physical office building to have a place of business in India anymore. Global Tech's website? Oh yeah, that totally counts. The only tiny exception to remember is for offerings made within an international financial services center. And you know ICI, they love to test the edges of these definitions. So remember, a place of business isn't just a fancy sales office. It could be something as simple as a share transfer office. Or think about international airlines, that network of booking agents they use. Each one of those can be considered a place of business. It just shows how even a tiny footprint in India can trigger the rules of this whole chapter. All right, moving on to a really critical area. We're diving into Section 379 and what I call the 50% Indian holding trap. You need to pay very close attention here because this is where a ton of marks get lost. Why? Because it completely changes the rule book for the company. And this takes us right back to that very first question I asked you. The magic number you have to burn into your memory is 50%. If 50% or more of the paid-up share capital, and that includes both equity and preference shares, of a foreign company is held by Indian citizens or Indian companies, a whole different set of much stricter rules gets activated. Just look at this comparison. On one hand, a regular foreign company just has to worry about a handful of sections, mostly 380 to 386. But the moment you cross that 50% Indian holding line, boom, you have to comply with all of those sections, plus a whole bunch of other provisions from the Companies Act, literally as if you were an Indian company. The compliance burden just explodes. Here's a perfect example of how this plays out. Take a look at MR Company from Dubai. One Indian company owns 26%, and another Indian company owns 25%. Now, individually, neither is a majority shareholder. But what happens when we add them up? We get 51%. They've crossed the threshold. So now, MR LLC has to follow all those extra tougher rules, just like any company born and bred in India. So, we've identified our company as a foreign company. What's the very first thing it needs to do? That's covered in Section 380, the initial registration. I want you to think of this as the company's application for an entry visa to do business in India. And trust me, the timeline is not flexible. The clock starts ticking the moment it establishes its place of business. Within 30 days, it absolutely must file Form FC1 with the registrar in New Delhi. What goes in it? A certified copy of its charter documents, like its MOA and AOA. And a key detail, if they aren't in English, you need a certified English translation. The form also requires the full address of its main office back home and its main place of business here in India. Next up, It has to provide a detailed list of all its directors and the company's secretary. And this next part is super important. It has to name at least one person who is a resident in India and is officially authorized to accept legal notices on behalf of the company. This makes sure there's always someone accountable on the ground here. Lastly, it needs a declaration stating that none of its directors or representatives have been convicted or barred from acting as a director. Let's make this real with an example right from the study material. A company from Singapore sells its products online to Indian customers. No physical office. Do they need to register under Section 380? The answer is a big, clear yes. And why? You got it. Because conducting business via electronic mode creates a place of business in India. That starts the 30-day countdown to file Form FC1. Okay, so the company is registered. Great. But the paperwork is far from over. Section 381 lays out the annual rules for accounts and audit. You can think of this as the yearly renewal of their permission to operate here. So every single year, the foreign company has to cook up a balance sheet and a P&L that shows just its Indian business operations. These financials, along with a complete list of all its business locations in India, have to be filed with the registrar. The form for this is Form FC-3, and the deadline is tight, within 6 months from the end of its financial year. The registrar might give an extension, but it can't be for more than 3 months. Now let's talk about the attachments, because this is a detail that students often forget in the exam hall. When you file that Form FC-3, you have to attach 3 very specific statements. You'll need one detailing all related party transactions, another one on the repatriation of profits, meaning money sent back home, and a third one on all transfers of funds, which includes dividends. And here's a non-negotiable point you absolutely cannot forget. Audit is mandatory. The financial statements for the Indian business operations must be audited by a practicing chartered accountant right here in India. All the regular audit rules from Chapter 10 apply here, mutatis mutandis, which is just a fancy legal way of saying they apply with any necessary small adjustments to fit the situation. All right, let's quickly cover the day-to-day rules. These sections might seem small, but they are prime material for MCQs or short answer questions. These are the easy marks you really don't want to leave on the table. Section 382 is all about being transparent. The company has to display its name and its country of incorporation outside every single office. And it has to be in English and the local language. Those same details have to be printed on all its business letters, bills, and notices. And if it's a limited liability company, it has to say so clearly. Then we have Section 383, which makes serving legal documents simple. Any notice sent to that authorized person we talked about earlier is considered officially and legally delivered. Getting close to the finish line. But this is a big one. It's so important to understand that Chapter 22 isn't on some deserted island. Section 384 is like a bridge that connects it to many other significant parts of the Companies Act. What this means is that a foreign company operating in India also has to follow the rules on debentures, it has to file an annual return just like an Indian company, and it has to maintain proper books of account for its Indian business. The rules for registering charges against its Indian assets apply, the CSR rules can apply if they meet the thresholds, and very importantly, their Indian operations can be investigated by the authorities. So please never ever ignore these cross-references in an exam. Okay, let's do one final test to make sure this all sticks. A company from Singapore has just one presence in India, a share registration office in Mumbai. Is it a foreign company? Yes, absolutely it is. The definition of place of business specifically includes a share registration office.
Okay, let me hit you with a classic exam trap right off the bat. Imagine this. A company is incorporated in Singapore, but look, all its directors, all its shareholders, they're Indian citizens. So the big question is, under the Companies Act, is this a foreign company? Now think carefully. Getting this wrong is a really common way students lose easy marks.
And the answer is not necessarily. And listen, this is exactly where ICAI loves to catch students out. The key thing you have to remember is this. The nationality of the shareholders or directors is completely irrelevant. It just doesn't matter. For a company to be a foreign company under our Act, it has to tick 2 boxes. 1, it must have a place of business in India, and 2, it must actually be conducting business activity here. Remember those 2 conditions.
Okay, now that we've got the definition straight, let's get into the core rules. So, when a foreign company wants to raise money from you, the Indian public, its whole journey starts with the prospectus. Think of it as their entry ticket, and Section 387 lays down all the ground rules. This is our starting point. First things first, and this is an absolute non-negotiable. Any prospectus that a foreign company issues here in India has got to be dated and signed. It sounds simple, I know, but this is the first, most basic compliance check, and every other rule we're about to discuss builds on this one.
So, what exactly has to be in this prospectus? Well, Section 387 gives us a nice little checklist. You need the company's constitution, its rule book. You need the laws of the country where it was born. You need an address here in India where anyone can go and look at these documents. The date and country of incorporation, of course, and finally, a clear statement on whether it has a place of business in India. Just treat this as a mandatory checklist.
But wait, there's more. It doesn't stop with those 5 points. On top of all that, the prospectus also has to include everything, and I mean everything, that an Indian company needs to put in under Section 26. So, hey, that's good news, right? All that stuff you already learned about domestic prospectuses is directly useful right here.
Okay, everyone listen up. This next part is super, super important. Like highlight this in your notes important. ICIA absolutely loves to test exceptions, and Section 387 has a huge one. We're talking about the 2-year proviso. This is a classic spot where marks are lost because of a small adjustment in the question.
So what's the deal with this 2-year proviso? Well, it's basically a relief, a kind of break for more established companies. If a foreign company issues a prospectus more than 2 years after it was legally allowed to start its business, it gets a pass on some of the paperwork. It doesn't need to include those first 3 items from our checklist, the Constitution, the incorporation laws, and that Indian inspection address. So, when you see a date in an exam question, alarm bells should be ringing. They're almost certainly testing you on this exact point.
Now, this next point is all about protecting the investor. So can a company try to be sneaky and put a clause in the application form that says, hey, by applying for these shares, you're giving up your right to sue us if our prospectus is wrong? Absolutely not. No way. Section 387, subsection 2 is crystal clear. Any condition like that is totally void. A company can't trick you into waiving your rights.
In this slide is brilliant for showing the other 2 exceptions under Section 387. Look on the left. If a foreign company is making an offer to its existing members or debenture holders, well, the entire Section 387 just doesn't apply. It's considered an internal matter. But look at the right. This is a different scenario. If they're issuing securities that are pretty much identical to ones already trading on a stock exchange, they get a huge break. They don't need to give all those particulars. They just have to make sure the prospectus is dated. See the difference? One is ignore the section. The other is just get the date right.
Okay, so we've sorted out what needs to go in the prospectus. What's next? You can't just print it out and start handing it around. We have to handle 2 more crucial steps before it can be issued: dealing with expert statements and, of course, getting it registered. That brings us to Sections 388 and 389.
Now, if your prospectus includes a statement from an expert, say a valuation report or some technical assessment, Section 388 is very, very clear. You absolutely must have that expert's written consent. But more importantly, if that expert withdraws their consent before you've registered the prospectus, you cannot issue it. Full stop. And the prospectus itself has to say loud and clear that the expert gave their consent and, crucially, that they have not withdrawn it.
This is a simple but critical rule about the sequence of events. You cannot circulate a prospectus in India until a copy of it has been delivered to the Registrar of Companies for registration. It has to happen before the issue. Think of it like this: get the official stamp of approval first, then show it to the public.
So, what do you actually give to the registrar? Well, Section 389 and Rule 11 give us another handy checklist. This is your compliance package for the ROC. You'll need a certified copy of the prospectus, that expert's consent we just talked about, key contracts like for the MD or manager, any other material contracts from the last couple of years, the underwriting agreement, and a power of attorney if an agent signed everything.
All right, let's zoom out a bit. Foreign companies don't just interact with India by issuing a prospectus. There are 2 other really important areas we need to cover: Indian depository receipts, or IDRs, and cross-border mergers. These are definitely advanced and very testable topics.
So what in the world is an IDR? Let's break it down simply. It's basically a way for us here in India to invest in foreign companies on an Indian stock exchange. The foreign company gives its shares to an Indian depository, and that depository then issues a receipt, the IDR, to Indian investors. You can then buy and sell this IDR just like you would a share of an Indian company. Section 390 is what gives the government, along with SEBI and RBI, the power to make all the rules for this.
Now for the big one: cross-border mergers. This is all governed by Section 234. This section is a game changer because it allows an Indian company to merge with a foreign company or a foreign company to merge into an Indian one. We're talking about huge strategic possibilities here. But you can't just do this on a whim. There are strict rules. Rule number 1, and you absolutely cannot forget this, you must get prior approval from the Reserve Bank of India. No RBI approval, no merger, period. And what about paying the shareholders? The law gives some flexibility here. The payment can be in cash, it can be in those depository receipts we just talked about, or it can be a combination of both. You should definitely remember these payment options for your exam.
We've covered all the rules and all the things you're supposed to do. Now what happens when things go wrong? The consequences for not complying are severe, and you know the ICAI loves to test penalties. So let's dig into sections 391 to 393.
The law makes zero distinction here. Section 391 is very clear. If there's a misstatement in a foreign company's prospectus, the exact same tough rules on criminal liability, civil liability, and punishment for fraud that applied to Indian companies will apply to them. There are no exceptions.
And Section 392 puts some real numbers to the general penalties. For the company itself, the fine starts at 1 lakh and can go up to 3 lakh rupees. But the real sting is the continuing fine, 50,000 rupees for every single day the mistake continues. Ouch. For the officer in default, the personal liability is a fine anywhere between 25,000 and 5 lakh rupees. These numbers are really important for case study questions.
Here's another classic scenario based on Section 393. A foreign company didn't follow the rules of this chapter, but they went ahead and entered into a contract with Mr. A, an Indian citizen. So, is that contract now void? Can Mr. A enforce it? And can the company enforce it?
This is a fantastic point, and ICAI really tests this logic. The answer is right there on your screen. First, the contract is still valid. The company's failure doesn't just make the deal disappear. Second, the innocent party, Mr. A, can absolutely sue the company to enforce his rights. But, and here's the crucial part, the defaulting foreign company loses its right to sue Mr. A. They can't bring a case or make a counterclaim until they fix their non-compliance. It's a one-way street designed to protect the Indian party.